All right, so what I'm going to do now then is I'm going to be handing over to my colleague in Thiope, and she's going to be taking us through a case study. So in Thiope, over to you.
Thank you so much, Ashley. So as Ashley introduced me, I'm in Thiope Nelson. I'm a senior analyst within our monitoring and analysis division. Liz and Ashley gave you a good background on the sanctions regimes and the applicable legislative framework. So I'm just going to take you through a case that the FIC worked on in dealing with the United Nations sanctions. Thank you. So the case study, Ashley, can you see my screen? I think I have shared my screen.
Yes, now we can see your screen and we can hear you.
Okay, great. Okay, so let me just get to the next slide. Somehow I think I'm not doing something. Can you see that I've moved on to the next slide?
In Thiope, we can see the slide that says case study Alu Abu Bakar Tantoush, with the picture of a man with glass. Now we're back to your main screen, the one that says case study.
Oh, okay. All right. Okay, so South Africa has only had to implement the United Nations Security Council Resolution 1267 against one individual. Ali Bakar Tantoush was a South African resident for the period 2003 to 2014, and he was listed by the United Nations. Tantoush is a Libyan national, so he was a South African resident, but a Libyan national. He entered South Africa on a false South African passport under the name Abdel Ilah Sabri. And once Tantoush came into South Africa, he applied for asylum, and that was in November 2003. So the Libyan government applied to South Africa for Tantoush's extradition on the grounds that he had stolen gold, the proceeds of which he was going to use to fund the Libyan Islamic Fighting Group. Interpol also circulated a notice that Ibrahim Tantoush was a wanted person. So despite Tantoush being circulated as a wanted person, the Pretoria Magistrates Court ruled that the extradition proceedings against Tantoush should be struck off the roll, so he was not extradited to Libya. And during September 2004, Tantoush was granted refugee status in South Africa. I've listed the case number for those legal eagles out there who might be interested in actually reading about the case. So then you can actually get some more detail just exactly about how Tantoush had gone through various countries before he eventually landed in South Africa, and you can read as well the judgment. One of the judges actually made an interesting case as to why he found that Tantoush should be granted refugee status in South Africa. Debatable, but yeah, read it for your own interest if you like. So while in South Africa, the Financial Intelligence Center looked at Tantoush's financial activities because he was on the UN list. He lived in Johannesburg. He had no family that we knew of, although UN information indicated that he was divorced from an Algerian lady. We know that he used about 13 aliases while he was in South Africa and also before he actually came to South Africa. The way he sustained himself was mainly on living on a cash basis. So his cash lifestyle was confirmed when we looked at is the fact that he wasn't really involved in our formal banking system. He opened an account with one financial institution, but there was limited activity. He opened a savings account in July 2005, which was 2 years after he came into South Africa, with an opening deposit of 50 Rand. And then later on in that same year, he made a cash deposit into his account of 50 Rand. So we know that the first deposit was made in Braamfontein and the second one in Lenasia, which confirms that he mainly moved around Johannesburg, Gauteng area. So besides those two activities, there was no other significant transaction movements on his accounts. The account was then closed in December 2006, just about less than a year later, due to the dormant status. And the significance about all of this is that Tantouche had no assets that South Africa could freeze in line with our obligations to the United Nations. So Ashley spoke about the fact that persons who are designated by the United Nations are also designated in terms of Section 25 of our Pacta Tara. And so in 2010, the government of South Africa designated Tantouche. And subsequent to that, well, actually 4 years later, Tantouche left South Africa for Libya on a chartered flight using a Libyan passport, And so South Africa was kind of off the hook there because he was no longer a resident. He had gone back to Libya, and in accordance with Section 5 of the Refugees Act, South Africa revoked his asylum status. So what happens is if someone applies for asylum status, but then returns to the country from which they were fleeing, and they return on a voluntary basis, the host country can then revoke the asylum status, and that's what the South African government did in terms of Tantouche. As far as his whereabouts, we know that Tantouche is currently in Libya, and yeah, I don't know whether I can say alive and kicking, but we do know that he's in Libya. And so that is what we know about Mr. Tantouche, and that was the case study and the only individual that South Africa had to deal with in terms of United Nations Security Council listing. So thank you, Ashley. That's all from me. Thanks a lot.
Thanks so much, Nthapi. And I think, you know, even though it's just reduced to a few slides, I know you can talk probably being one of, you know, being part of that team that's responsible is, it couldn't have been done without the information that got submitted through STR reports or through TPR reports. And we really, and I know I'm harping on it, but it really is the lifeblood of the FIC in terms of us being able to gather intelligence, create intelligence, and pass it on. So the information in the reports really is very crucial and valuable to us. So that then brings us to the end of the formal session, and we are going to open up. We are going to open up the Q&A. So what I will do is I'm going to ask my colleagues to take their mics off of mute. And I actually didn't mention it up front. We are assisted by our ICT colleague, James, who's very kindly been assisting us with all our webinars. And I think just to make his life easier, you know, whoever wants to answer the question, you're more than welcome to add to each other's questions. And I always think we from different departments within the FIC. So I have a look at it from, you know, a compliance angle. Lise looks at it from, you know, an international legislative angle, and Nthapi then from an analyst perspective. So having actually seen the information and compiling the intelligence. So it really is, it's a very interesting angle, and we can all have, you know, multiple answers to the same questions. So what I am going to do is I have seen some questions published. What I'm going to do, I'll just give you a few seconds just to have a look at the questions. I'm going to filter them by the most liked, and then we're going to start answering the questions with the most liked. So while you have a quick squiz at the questions that are there, I can already see one is being liked the most. Just remember the attendance register. If you do want to receive the presentation, we're going to be sending it out to everyone who attended today's session. I see that there's 514 people who have completed the register. So if there's anyone else who needs to, you know, you've got about 30 odd minutes, 28 minutes to be precise, to fill out that register. Just a reminder around the presentation, the video is very, very big when we download it. So we haven't figured out just yet how to how to email it out, because it's obviously too big for our server, and we're also not able to host it on our website because the images or the video is too large. So we are working on it. Just give us some time, but what we will be doing is we will be sending out the presentation in latest Friday, so you would at least have a chance to have a look through that. Some of the acronyms that we were asked, again, just around the FATF. The FATF is the Financial Action Task Force. They're the international standard setting body. They set the 40 recommendations. Interesting story, it used to be 40 plus 9. The plus 9 came as a result of the 2011 events that took place, and those plus 9 then touched on specifically on terrorism. Those then got incorporated into the recommendations. So now it's just the 40 recommendations. And, you know, and I think it's important. I think, Lise, I don't know if you want to step in, that change is very important, that it's not a plus 9 anymore. It's not a, oh, and now we're going to deal with TFS. It really is, okay, AML and TFS, this is what we're dealing with.
Yes, thank you, Ashley. Just a few general remarks from my side. I think there wasn't enough time to go into any level of depth of what is required from us as a country when we do get assessed. But I think I might have mentioned in passing, we do get assessed as a country from time to time under the changing global standards. South Africa is also a member of the Financial Action Task Force. There's only about 36 members currently. But through its international footprint, most countries in the world, including the small island states, get assessed under the FATF criteria, and the UN Security Council also cross-referenced the assessment criteria that FATF developed. Now, the most recent set of recommendations was amended in 2012. As Ashley mentioned, right after 9/11, the events of 11 September 2001, a series of counter-terrorism financing resolutions was added at that stage in round 3 of the assessment criteria. It was known as the 40 plus 9, 40 being primarily focused on money laundering, and where the concept of money laundering originated from the international concerns around drugs and organized crime and all those international conventions when FATF was first established at the end of the 80s. That was before my time. But since then, this organization evolved, as we've repeatedly said, the international standard setting body that even the United Nations now refer to and defer to when they conduct assessments by their panels of experts using the Financial Action Task Force assessment criteria and standards, which are both the recommendations, the 40 now, integrated to also contain after 2012 a set of recommendations that refers to counter-proliferation financing. So when we started working on this, Ashley just reminded me when she spoke so highly about and with such passion about the involvement in the FIC's project when we developed the targeted financial sanctions regime and system and a search list, and that we started making those presentations. I'm talking about a couple of years ago now, before we even looked at the amendments of the Financial Intelligence Center Act. And I remember when I started giving presentations about this, we referred to as targeted financial sanctions to terror financing standing a little bit outside, and then targeted financial sanctions relating to proliferation financing standing way outside. So subsequently, I think with the last round of assessment criteria, under the current round of FATF assessment criteria for effectiveness, this has been found to be part and parcel of our understanding of risk. So understanding of your client's risk is no longer something as an add-on to look into the list of United Nations Security Council resolutions. I'm going to answer another question that comes up frequently. While we both talk a lot about, myself and Ashley in our presentations, on the implementation of United Nations Security Council resolutions as an institution out there, a business, a financial institution, or any other business or profession, you might also look at other unilateral or country sanction regimes, depending on your clientele, on the products and services and jurisdictions you work in. So keeping all of this in mind, but focusing it within what is expected from the global standard setter and within our current legislative framework that does not currently encompass looking at those sanction regimes. As a business, you need to make a judgment call, a risk assessment based on your clients, their products, their services, and who's sitting beyond them and who might control their affairs as a gatekeeper, as a register of companies, as a lawyer, as an advisor. Keeping in mind financial assets also includes financial services. So it's really important to understand where all of this is coming from, how this is evolving over time, and how these issues are adapting. Last point before I'm going to hand back to Ashley, I think what we also need to keep in mind in line with the global focus is years and years ago, when sanction regimes just started, it seemed unfathomable to do business with North Korea. But today, we are doing business with them. We're a global village. That doesn't mean you need to de-risk your clients. That doesn't mean you need to get rid of your clients who currently do business. You need to be aware of your clients, what kind of products they are currently trading with, their partners, their counterparts abroad, and in what jurisdictions they trade. So first and foremost, understanding where your risk as an accountable institution and a business is in understanding the risk that your client might have in dealing with either listed entities wittingly or unwittingly. I think I talked about a lot of things now. Ashley, back to you, maybe for more specific questions. Thanks.
Thanks, Liz. Before we go into the questions, I just want to maybe check with Nthaiphi, just in terms of the UN ODC, what is the relationship there? Because, I mean, we've spoken now around FATF as the international body, and then we have, our engagements with the UN ODC. How does that relationship play out?
In terms of the UN ODC and sanctions, or can you?
Yeah. So from a sanctions perspective, are there any local bodies from a South African perspective, or is it really, I'm not too sure if this is aimed at you or Liz. Is our relationship just with the FATF, or are there any other bodies that we maybe report to or give us assistance in this regard?
Okay, I think maybe this is a question that Liz can answer.
Sorry, Liz.
Sorry, Liz. Throwing the ball into your court.
Not a problem. Let me jump in here. Primarily, in terms of our domestic legislation, we only deal with the implementation of United Nations Security Council resolutions, and not all of them. We've said over and over, it's only those under Chapter 7. So it's those 14 sanction regimes, the ones I presented in the blue circle. The ones outside of them either do not have a listing requirement and is not currently part of the consolidated list of targeted financial sanctions. Keeping in mind, we're focusing on targeted financial sanctions. Beyond that, in the other circles, the other peripheral sanction regimes are either country specific or regional specific that we need to be aware of. And most large financial institutions do have access and do screen and check against what's commercially available. We are not going to mention any names, but you are more familiar with what is available in the market out there, because we don't want to endorse anything. But we developed in-house in the FIC, and I also saw some comments coming through. Thank you for the compliments. Why don't we add the list that's currently under the SAPS legislation? We're currently thinking about that. So that will involve amendment of both POCTATARA and FIC Act. We have no other obligation domestically to implement any other country sanction or autonomous, unilateral, domestic, whatever you want to call it. So as for the questions regarding OFAC, that is the Office of Foreign Assets Control of the United States Treasury, they have various rules. They various requirements. If you operate in a global format, I might have mentioned it in passing, and you operate in the dollar economy, that might affect your business. It might affect your client base, it might affect your correspondent banking relationships. But you have no obligation to implement the OFAC or an Australian or a Canadian or a UK Treasury sanction list or an EU sanction list.